Good afternoon, my lord. I'm Harris and I appear on behalf of the pursuer. In this case, following on from an options hearing, the learned sheriff fixed a debate on the pursuer's preliminary plea in terms of Rule 22. The pursuer has lodged the Rule 22 in which they have set out a note on the basis for the plea, and the pursuer has intimated this to the defender. In that, the pursuer rely on their first plea in law and the principal action in respect that the defenders admit they are due liquid sums to the pursuer in relation to the parties' contracts for the supply of asphalt to various locations on various dates, where there are no averments that the pursuers were in breach of those contracts. The defenders seek to retain payment of those amounts pending determination of the counterclaim. They cannot relevantly do so, as those supplies relate to separate contracts. Decree should be pronounced for the sums due. Therefore, my lord, the pursuer craves for the court to grant summary decree of the price of £39,600 for the liquid sums due, and for the court to allow a proof before answer in regards to the defender's counterclaim. Now, in support of this, I will demonstrate to the court that the defender admits that they are due liquid sums to the pursuer, therefore qualifying the action as breach of contract. Thereafter, I will take the court to the counterclaim and demonstrate that retention should be repelled by the court, as there is nothing to justify the court to depart from the general rule against retention, and it would be unjust to grant the motion in favour of the defender. My submissions to support this are as follows. The pursuer's claim is liquid, and that the defender's claim is illiquid. Number two, the defender's counterclaim arises out of the provision of just one order of the bitumen mixture on the 25th of November 2018. The defender's counterclaim also of 95,000, whilst they have a schedule of loss, they have not provided any evidence to support the claim, for example, any bank statements or receipts from contractors, just the schedule, and therefore it is not instantaneously verifiable. The number four, the defenders do not suggest that they are in any financial difficulty and that bankruptcy is not a consideration for the court today. Number five, that this case involves two commercial entities, my lord, and that they are on equal standings, and there's no prejudicial conduct that can come out from that. And number six, the defender's case will require to go to a proof before answer, which will be some way off, and there is nothing obvious at the outset and from the record to demonstrate that they are bound to succeed, and there is nothing to justify the court exercising in its equitable discretion over the matter. Therefore, decree de pleno and the principal action should be granted, and a proof before answer allowed with regards to the counterclaim. I'm sure my lord is familiar with the record, however, if I could just give you a brief summary of the facts. Now, the pursuer supplied the defender with asphaltic road materials. The defender ordered said materials between June the 17th and the 28th of November 2018. The pursuer delivered materials to various sites including Alloa, Edinburgh, Bothwell and Kirkcaldy, all for the benefit of the defender. A total of 12 orders of 95-tonne batches of the materials were made and ordered by the defender and to be delivered to the different sites over the period of time stated above. My lord, no payment has been made to date to the pursuer for any of the asphaltic road materials. On delivering a batch on the 26th of November, the pursuer delivered 95 tonnes to the Kirkcaldy site as agreed. The defender at the time checked the batch, and no complaint was made to the pursuer with regards to the quality of the materials nor the conditions into which they were stored. The defender's position is that on the 26th of November 2018, the pursuer supplied a bituminous mixture below the optimal temperature, and as a result, the materials became defective, thus contributing to the loss of the defender. Notwithstanding, they allege that the pursuer is in breach of an implied term of that contract. And as a result of this, the defender seeks to exercise their right to retention and offset liquid debts against illiquid claims for damages. My Lord, the pursuer does dispute these claims and rests liability solely on the head of the defender, as their position is that the defender were the ones responsible for letting the temperature drop. The reasoning being that the defender had left the bituminous mixture too long outside, thus allowing it to cool. My Lord, there are many factual and legal matters in dispute here, and given the complex nature of the mixture and the temperature issues that are in dispute, I would invite His Lordship to agree that a proof before answer would be necessary given the intrinsic nature of the manufacturing process. I will discuss this position of the defender and apply legal authority later in my positions. It is the pursuer's position that the contracts are created each time an order is made, or each time that a phone call is made to make the order and to get the delivery. Thus making all orders separate individual contracts. The defender has made no complaints regarding any orders out with the order made on the 25th of November 2018. If I could direct your Lordship to the invoices, under production 1 it is invoice 45678, which is dated the 18th of June 2018. Production 2 is invoice 45679, dated the 20th of June 2018. Production 3, which is invoice 34567, which is dated the 18th of September 2018. Production 4, which is invoice 34568, which is also dated the 18th of September 2018. Production 5, which is invoice 23456, dated the 30th of October. Production 6, which is invoice 23457, which is also dated the 30th of October 2018. Production 7, which is invoice 23458, dated the next day on the 31st of October 2018. Production 9, which is invoice 12345, which is the date of the 12th of November 2018. Production 10, which is invoice 12346, which is dated the 15th of November 2018. Production 11, which is invoice 12347, which is dated the 26th of November 2018. Production 12, which is invoice 76543. And finally, production 13, which is invoice number 76544. As my Lord can see, these last two were made on the 28th of November and were split across two other sites, one in Bothwell and one in Kirkcaldy. And as my Lord could see from these documents, payment would be due 30 days after the date of the invoice being issued. Now, in accordance with the record, my Lord, no payment was made to the pursuer for any of these materials. And what's important to note with regards to these invoices is that payment was past due long before any claims of defective material were made by the defender. Admittedly, the defender claims that they only became aware of the defects in January. Furthermore, under the statement of facts, it is admitted by the defender that they have refused to make payment despite the pursuer's demands to make this payment. My Lord, this illustrates the defender's complete unwillingness to make payment for any materials. I would invite His Lordship, in light of the above submissions, to take the view that the debts incurred by the defender over the time are in fact all liquid. All bar one, my Lord, which is production number 11, and invoice 12347, dated the 26th of November. The record reads, my Lord, that this is the batch that is in dispute here, and none of the other agreements were flawed. I suppose the only flaw would be that the defender has breached the terms in their failure to make good on payment on these agreements. My Lord, this agreement was made over the phone, and all of them subsequently were made over the phone, and this is when we submit that the contract was formed. If my Lord can look at the production number 9, please. Lord, this is a quotation sent from the pursuer detailing the price of a subsequent purchases. I would submit that this is a quotation and nothing more. The defender is not bound by this agreement and need not take any actions in connection with the quotation. There are no intentions to create legal obligations. Intentions to create legal obligations from the pursuer. However, no such intentions follow from the defender, and only when a phone call is made are these terms incorporated. Lord, I will now move on to the issues regarding the retention and the defender's counterclaim of the sums due, supported with legal authority. Lord, if I can draw his attention to McBride, the Law of Contract in Scotland, 3rd edition, under paragraph 2062. It's under the yellow tab under the highlighted section of the bench copy, my lord. It states that liquid debts may be set against each other. This does not apply to illiquid debts. In mutual contracts, parties may withhold performance when they have illiquid claims, not because of any legislation, but because of the mutuality principle. Now, in explaining this mutuality principle further, I would direct my lord to comments made by Lord Drummond Young in Purac versus Bizac, 2005, reported in the Scottish Legal Times at 37. If his lordship would like to draw his attention to paragraph 43, it is the red tab under the highlighted section. Lord Drummond Young states the critical point about the right of retention is that it is based on mutuality of contractual obligations. In the present case, my lord, the defender is under no obligation to buy the material. It is at their discretion until they make the call and order. Lord Drummond Young goes on to state, still at 43, that it is clearly established that the right of retention can be based on an illiquid claim. In the present case, the amount of the illiquid claim is for £3,600 for the alleged defective batch. The pursuer accepts the possibility that there will be a proof before answer to decide whether the illiquid sum will be retained by them. However, the outstanding liquid debt as craved is not connected to the contract, as it lacks interdependence and mutuality for reasons previously stated. The agreement that was made on the 25th of November 2018 does not have a sufficient connection with the other agreements, therefore not invoking the principle of mutuality. If I could draw his lordship's attention to Barton Distilling Scotland Limited versus Barton Brands Limited 1993, which is reported at the Scottish Legal Times at 1261. Excuse me. My lord, this case is similar to the one that comes before the court today in that it deals with the defender's counterclaim that was based on the loss of profits. The basis of the counterclaim was that both parties were involved in a course of dealings where the defender had agreed to purchase whisky from the suppliers with the intention of selling the said whisky. It was further alleged that the seller had failed to supply the whisky, and as a result the defender had suffered loss. If his lordship would like to draw his attention to paragraph 1262, the critical facts in relation and similarly to the present case was that Barton both parties were agreed that the principal action for the liquid claim and the counterclaim was illiquid and required proof. The course of dealings was not substantial enough to qualify as the same contract, and that only when there was a single contract or a series of transactions that could be properly looked upon as a contract, to the extent that there was true mutuality between parties, a plea of retention could be upheld for an illiquid sum against a liquid debt. This is neither the case in Barton nor in the present case today. In Barton, still at 1262, my lord, the defenders in this case relied upon 4 exceptions to the rule, namely being, number 1, where the liquid claim admitted of instant verification. Number 2, where the liquid and the liquid claim arose out of a mutual contract. And number 3, where one or the other party was bankrupt or virgins ad onopium. And number 4, where the exceptional circumstances, retention was allowed to meet the justice or convenience of the particular case. If I can apply the exceptions to the current case, my lord, first of all, the instant verification is not possible, as the dispute regarding the specialist nature of making and sustaining the bituous mixture goes past what the court can decide upon, and investigations will need to be had to ascertain who is liable for this loss. Now, under paragraph 1268 of Barton, my lord, on page 9 under the highlighted section, this was rejected by Lord Osborne. He stated that proof would need to be led in regards to establishing the failure to supply, although he claimed that establishing the market value would not involve any great difficulty. The same could not be said for establishing the failure to supply the whisky. Now, I would submit that the difficulty in establishing liability regarding defective materials in the present case would prove more difficult than the Barton's failure to supply, my lord. Therefore, instant verification not being possible in the current case. It has been established above, and I have stated that the mutuality and interdependence of terms can be called into considerable question, and Barton takes us further in that under paragraph 1268, my lord. Lord Osborne, while quoting Globe on Contract, 2nd edition, at page 624, states that a debt which is admittedly due and payable cannot be withheld on the plea of retention in respect of damages which does not arise out of the same contract when applying it. And that's what happened when Lord Osborne applied it to Barton. He further stated that I do not think it is enough to justify retention that the defenders placed a succession of orders with the pursuer. At 1269 of Barton, he goes on to state that the course of dealings is not the same as a general account. This can also be applied to the current case in that all but one of the orders had defective materials, or allegedly had defective materials, my lord. The other transaction cannot be regarded as a general account, and that are at the very most they are a course of dealings, but cannot be regarded as the same contract, thus rendering the defenders in breach of a material term for the non-payment of the invoices for the orders that had no defects. There is no mention from the defender, it certainly hasn't been intimated to the pursuer or even in the record that there is any danger of bankruptcy or even verging on bankruptcy, my lord. What they do have, and they seem to have, is a schedule of loss without any real proof. With regards to that, I do understand that it will go to proof. However, at the outset, it doesn't look good, my lord. They don't have any receipts or any bank statements to back up their claims of loss, my lord. Now, the last exception, namely the exceptional circumstances, that retention was to meet the justice or convenience of the case. I would submit that the justice and convenience would be for the defender to pay the liquid sums due, as the court does not have the equitable discretion to allow retention in this case, as they couldn't possibly comment on the specialist nature of the debate, and proof would be required here. Now, none of the above exceptions are valid in the present case, and His Lordship should grant the decree as craved. Finally, if His Lordship would like to draw his attention to Inveresk plc versus Tullis Russell Papermakers Limited 2010, which is reported in the Scottish Legal Times at 941. My lord, it is the purple tab under the highlighted section at 962 under paragraph 107. Now, Lord Roger brings a situation into the modern world, and he states that while the court has the equitable power, the judges constantly remark that an illiquid claim cannot be set off against a liquid claim. When they use this formula, the judges are really saying that The established general rule is that the court will not permit a defender to postpone payment of a liquid debt so as to have the opportunity to make liquid what is presently an illiquid claim against the pursuer, and then to set the liquid debt off against the liquid debt which he presently owes to the pursuer. In the present case, this would suggest that the defender cannot set off an illiquid claim against the pursuer's liquid debt, and that the defender should pay the pursuer the liquid debt as craved, and the counterclaim concerning the one contract should be sent to proof before answer. My Lord, the pursuers move the court to grant decree de pleno as craved and to allow proof before answer in respect of the counterclaims. My Lord, those are my submissions. I am obliged.